Here it depends on which chapter of the bankruptcy code you filed under. If you filed under a Chapter 7, then there really is no mechanism in Chapter 7 bankruptcy for curing a pre-petition default. And perhaps I should define the term. On the day we file your bankruptcy petition, that is the petition day. Everything prior to that is pre-petition. Everything after that is post-petition. So if you have a pre-petition default in the Chapter 7, unless the creditor is willing to work with you to allow you to take some action to cure that pre-petition default, there really is no mechanism for being able to cure it. In the other two chapters that are available to individual debtors, there is a mechanism. Those chapters are 13 and 11. And each of those chapters involves some sort of multi-year debt repayment plan. The plan does have to be approved, or the word we use is confirmed, by the bankruptcy judge appointed to the case. And if you can propound a plan that passes muster in a way that can be made precise, then you can use the plan to spread the cure payments over the life of the plan. The average Chapter 13 case lasts 5 years, 60 months. If your income is below the median income, then you can have a shorter plan. But for the most part, these plans are 5-year plans. In Chapter 11, things are a little bit more flexible, although most plans are 5-year plans, but they can be different sizes depending on quite a lot of factors, and that's for another day. The question that I usually ask somebody if this comes up during a consultation, person says, I'm behind on my mortgage payments, I'm behind on my car payments, what can I do? The first question I ask is, what's changed that makes you able to make these payments? And the reason for that question is, when you go into one of these plans of reorganization, from that day on, you must make every single secured debt payment, whether it's a mortgage debt or car loan payment, on time, just like clockwork. You can't miss any payments post-petition. If you do, that's considered a material breach of the plan, and the case can be dismissed or converted to Chapter 7. And so if there has been a material change that has rendered you able to do the cure, great. But not only will you have to make every post-petition payment on time, you're also going to have to make plan payments, and the plan payments have to cure this deficiency over the life of the plan. Now, the benefit here, of course, is if you're behind on the payments, you can spread the curing of that deficiency over the 5 years, rather than having to come up with a cure right away. If you were in a Chapter 7, it would be right away, or else you'd lose the asset. So sometimes the answer is, well, I lost my job. I was having a dickens of a time making ends meet. I missed a few payments, but now I've got this great paying job. I can make the payments and I can cure if I'm just given some time. Well, there's a situation that screams out, let's file a Chapter 13 or let's file a Chapter 11 and use the plan of reorganization to catch up on that arrearage. So yes, you can do it in bankruptcy, but probably not in a Chapter 7.